Human Rights and Employment, Self-Paced Learning. At the end of this video, you will be able to understand the scope of the New Brunswick Human Rights Act and its protections in the area of employment, identify the prohibited grounds of discrimination in New Brunswick, recognize discriminatory practices in recruitment and day-to-day employment situations, define the duty to accommodate in the workplace, including the concept of undue hardship, apply human rights principles by reviewing case law scenarios related to employment discrimination and accommodations, distinguish the rights and responsibilities of employers and employees under the Human Rights Act, understand the role of the New Brunswick Human Rights Commission in the province, and access the Commission's educational resources. The New Brunswick Human Rights Act and Employment. The New Brunswick Human Rights Act is the provincial human rights law that protects individuals in New Brunswick against discrimination and harassment related to prohibited grounds of discrimination in 5 protected areas, including employment. The Act's employment protections apply to all aspects of the employment relationship, including recruitment, job interviews, training, day-to-day work, promotions, and terminations. Under human rights law, employers also have a duty to provide a harassment-free environment and are responsible for the discriminatory actions of their employees, agents, representatives, and patrons in the workplace. They must also provide reasonable accommodations as needed or requested to allow individuals protected under the Act to fully participate in the workplace. The Act has quasi-constitutional status, which means that it has an elevated status amongst other laws in New Brunswick. This special status gives the Act authority over other laws, employment contracts, agreements, rules, practices, and policies in the province. The Act will overrule laws, contracts, rules, policies, etc., if they are found in violation of its protections. To determine whether a policy, contract, agreement, etc. is in violation of the Act, a complaint must be filed with the New Brunswick Human Rights Commission. If the Commission decides to refer the complaint to the Labour and Employment Board, the Board can make a finding that the law, rule, or policy violated the Act. The prohibited grounds of discrimination in employment. The Act prohibits discrimination and harassment based on 16 prohibited grounds of discrimination in 5 protected areas, including employment. These grounds represent your identity or personal characteristics like race, color, religion, sexual orientation, etc., which may make you more vulnerable to discrimination. The 16 prohibited grounds include race, color, national origin, ancestry, place of origin, creed or religion, age, physical disability, mental disability, marital status, family status, sex, which includes pregnancy, sexual orientation, gender identity or expression, social condition, which includes a person's source of income, level of education and occupation, political belief or activity. The Act also provides additional protections against sexual harassment and reprisal. For definitions of the grounds of discrimination, check out the resource Introduction to the Grounds of Discrimination on the Commission's website. Employment discrimination under human rights law. The Act prohibits discrimination in all aspects of full-time, part-time, permanent, casual, or probationary employment. It also applies to unpaid or volunteer employment opportunities, employment recruiters and agencies, trade unions, and professional associations. Discrimination in employment can occur even before an employee is hired, i.e., in job ads or during the recruitment and selection process. Employers have a legal responsibility to ensure that their hiring practices are fair and do not exclude or disadvantage candidates based on prohibited grounds under the Act. Practices which may be found to be discriminatory include discriminatory job advertisements that discourage or exclude individuals from protected groups. For example, stating a preference for young, energetic candidates or Canadian-born applicants. Asking inappropriate or intrusive questions on applications or during interviews. For example, asking about a person's mental or physical disability, age, family situation, religious beliefs, etc. Failing to accommodate an applicant's needs related to a protected characteristic during the hiring process. For example, failing to provide alternative reading formats for candidates with visual impairment. Screening out or refusing to hire applicants based on assumptions or bias related to their protected characteristics, such as rejecting a resume because of the applicant's name, appearance, accent, religion, disability, or background. Withdrawing a job offer after discovering that the candidate has a protected characteristic. For example, learning the candidate has a disability and will require accommodations at work. Similarly, during employment, employers have a responsibility to provide an inclusive and discrimination-free environment and to ensure that an employee's rights to dignity, privacy, respect, and accommodation are upheld throughout the course of their employment. Discriminatory treatment during employment may include demoting or withholding a promotion for an employee because they have become part of a protected group. For example, when an employee develops a disability during the course of their employment. Excluding a protected employee from workplace activities or decisions. For example, not inviting a colleague to a work event due to their religious needs for kosher or halal food. Making discriminatory comments, jokes, slurs, etc. about an employee's protected characteristic. For example, making jokes about an employee's sexual orientation. Failing to accommodate an employee's needs related to a protected characteristic. For example, refusing to provide a flexible schedule for individuals with childcare needs. Terminating an employee upon learning that they belong to a protected group. For example, terminating an employee who comes out as transgender or becomes pregnant during their employment. Not addressing an employee's allegations of harassment by coworkers, patrons, agents, and representatives related to a prohibited ground. Discrimination in employment. Case law scenario number 1. Perceived disability discrimination. Knight versus Société de Transport de l'Outaouais, 2007. Michel Knight was denied a job as a service attendant by the Société de Transport de l'Outaouais because he was missing his right index finger, and the employer believed he wouldn't be able to safely pump gas, a key part of the job. The Human Rights Tribunal applied the Meyerin test, which helps determine whether an employer's standard is justified. It found that the standard, i.e., requiring that employees must have all fingers to pump gas safely and efficiently, was connected to the job and adopted in good faith. However, the employer failed the third part of the test, as it did not assess Knight's situation on an individual basis to see if he could safely do the job or to consider possible ways to accommodate him in the position. The tribunal found the Société's actions discriminatory and that the employer had not accommodated Knight to the point of undue hardship. As a result, he was awarded $2,000 as general damages and $21,000 for lost wages. Duty to accommodate at work. Under the Act, employers have a legal obligation to take reasonable steps to remove any barriers or limitations that may be preventing current or future employees from full and equal participation in the workplace. This legal obligation is known as the duty to accommodate. An employer's duty to accommodate employees in the workplace includes making reasonable changes or adjustments to their rules, policies, practices, physical spaces, or operations to meet the reasonable needs of an employee who has a protected characteristic under the Act. For example, accommodating an employee who may need to work from home a few days a week due to a physical disability. These changes or adjustments are known as accommodations. Employees have a right to request accommodations at any stage, including during the application process, before or during an interview, after accepting a job offer, during onboarding, or at any time during employment. The duty to accommodate involves 3 key principles that employers must consider when providing accommodations in the workplace. These are dignity, personalization, and inclusion. Dignity. Accommodations must be provided in a way that respects an employee's self-worth and dignity. Accommodations should never embarrass, stigmatize, single out, or devalue an employee because of their protected characteristic. Employers must also protect the employee's privacy and avoid sharing personal information without their consent or with parties who are not involved in the accommodation process. Personalization. The duty to accommodate requires a personalized approach, as each employee's needs will be different, even if they share the same prohibited ground or diagnosis. This means that employers must take the time to understand the specific circumstances of the employee, their needs, and the potential accommodation options that will allow them to participate equally in the workplace. Employers should avoid a one-size-fits-all approach to providing accommodations, as this approach often fails to support the specific needs of a protected employee. Accommodation decisions should be made on a case-by-case basis and through meaningful communications with the employee. Inclusion. Accommodations should support the full and equal participation of protected individuals in the workplace, not to separate or isolate them from other employees. Wherever possible, accommodations should be designed to keep the employee engaged in the same work environment and activities as their colleagues. Employers should consider the various needs of their workforce when developing their policies, procedures, structure, tools, etc., to ensure the inclusion and participation of all employees. Examples of accommodations in the workplace. Some examples of workplace accommodations may include accommodating religious beliefs, scheduling flexible break times for employees who need to perform a religious obligation or make daily prayers, accommodating family status, adjusting work schedules to accommodate an employee to attend to their child's daycare schedule, accommodating pregnancy, providing an appropriate space and reasonable breaks for an employee who is breastfeeding, accommodating physical disability, providing an employee who has a visual impairment with a screen magnifier or other types of assistive technology, or adjusting an employee's job responsibilities to accommodate a physical limitation, accommodating mental disability, adjusting work hours to accommodate an employee who needs to attend a counseling session or other medical appointments, accommodating gender identity or expression, providing gender-neutral washrooms and changing areas for gender-diverse or non-binary employees. Undue hardship. Under human rights law, the employer's duty to accommodate ends at the point of undue hardship. The point of undue hardship is reached when the accommodation becomes too difficult, unsafe, or costly for the employer to implement. It is important to understand that undue hardship is evaluated on a case-by-case basis. This means that the employer must individually evaluate each accommodation request and the employee's needs before making the decision that they are unable to accommodate the request. Undue hardship cannot be used as an automatic excuse to refuse an employee's reasonable requests for accommodation related to a protected characteristic. If an employer claims that they can't offer an accommodation because of undue hardship, they must provide objective evidence like budgetary considerations, safety reports, financial statements, or expert assessments to show that they explored all possible accommodation options before reaching their decision. Subjective assessments, such as a belief or fear that the accommodation would be too costly or disruptive to the organization, are not sufficient to prove undue hardship. Minor inconveniences or discomfort of staff members or patrons due to an accommodation is also not a justified reason to claim undue hardship under human rights law. If an employer rejects an accommodation request without doing their due diligence or without exploring alternative accommodation options, they cannot claim undue hardship and may be subject to a human rights complaint. Some examples of undue hardship may include: a small business with tight finances cannot afford expensive equipment to retrofit an employee's workstation to accommodate their physical disability. A business with few staff members cannot provide extended leave to an employee who has family responsibilities, for example, taking their child to medical appointments, as it showed with objective evidence that the accommodation was putting too much strain on other workers. A company that operates heavy machinery cannot accommodate an individual with alcohol addiction because of safety concerns. Discrimination in employment. Case law scenario number 2. Family status discrimination. Simpson versus Pranajan Group Limited, 2019. Jessica Simpson worked as a personal support worker at a retirement home operated by Pranajan Group Limited for 4 years. During a proposed shift change, Simpson requested changes in work hours that would allow her to continue providing afternoon care for one of her children who had autism. The employer initially agreed to move her to a midnight shift. However, the employer withdrew the offer after Simpson called in sick, stating that she had not provided sufficient notice for her time off. When Simpson explained that she could not work an afternoon schedule due to her previously disclosed childcare responsibilities, her employment was terminated. The Human Rights Tribunal of Ontario found that the employer failed to accommodate Simpson's family status needs despite her reasonable efforts to find a workable solution. It also found the termination to be discriminatory and awarded her $30,000 in compensation for injury to dignity and self-respect. Rights and responsibilities of the employer. Under human rights law, both the employer and the employee have rights and responsibilities throughout the accommodation process to ensure that a reasonable accommodation is implemented. Responsibilities of the employer. Accept the employee's request for accommodation in good faith unless there is a legitimate reason for not doing so. Conduct individual assessments of the employee's needs related to the accommodation and cover the cost of any additional assessments required from experts where applicable. Work collaboratively with the employee to determine and implement a reasonable accommodation. In cases related to a disability or pregnancy, work with experts like doctors, psychotherapists, occupational therapists, etc., to better understand the employee's specific needs, limitations, and potential accommodation options. Take an active role in exploring different accommodation options in situations where the original request cannot be fulfilled. Document all aspects of the accommodation process, including any offered accommodations that may have been refused by the employee. Provide a reasonable accommodation that respects the dignity of the employee in a timely manner. In cases related to a disability or pregnancy, a reasonable accommodation must meet the needs of employees as determined by the treating medical professionals. Employers have a responsibility to accommodate any disabilities experienced by an employee, even if the disability is not the result of a workplace injury. Review accommodations regularly and look for alternative options if the offered accommodation is no longer working well for the employee. If an employer fails to properly accommodate an employee or to provide the accommodation in a timely manner, they may be found liable for discrimination if a human rights complaint is filed about the issue. Rights of the employer. Employers have the right to request reasonable information to support the need for an accommodation. This may include documentation such as a medical note or a letter from a religious institution to better understand the need for an accommodation and explore potential accommodation solutions. When requesting additional information, employers may ask medical professionals to identify any physical or mental limitations, provide their professional opinion on potential accommodation solutions, and indicate the prognosis for the time the restrictions or accommodations will remain in place. Employers are not obligated to create an entirely new position to accommodate an employee if it is not viable or useful to the organization. Employers are not obligated to accommodate an employee past the point of undue hardship. It is important to note that while employers may request documentation to support the need for an accommodation related to disability or pregnancy, they are not entitled to know the employee's specific diagnosis or the names of any medications they may be taking. They are only entitled to information about the employee's functional limitations, prognosis, or any medication side effects that could affect their ability to perform their job duties. Rights and responsibilities of the employee. As part of the accommodation process, employees have a right to have their privacy and personal information protected, including any medical or personal details disclosed as part of the accommodation request, be free from reprisal, punishment, or retaliation for requesting or receiving an accommodation, reasonable and timely accommodations that meet their needs related to a protected characteristic, request the modification of an existing accommodation if their circumstances change or the accommodation is no longer working well. Similarly, employees have responsibilities to fulfill as part of the process. These include providing adequate notice to the employer of the need for an accommodation, providing additional documentation, such as a doctor's note supporting the need for an accommodation when applicable, working collaboratively with the employer and participating in discussions regarding possible accommodation solutions, accepting a reasonable accommodation when it is offered, even if it is not their preferred accommodation, taking reasonable steps to ensure that the offered accommodation is successful, working with the employer on an ongoing basis to manage the accommodation, and providing feedback if the accommodation needs to be changed or modified. Under the Act, employees are only entitled to a reasonable accommodation that meets their needs. They are not necessarily entitled to a perfect or preferred accommodation option. In cases involving disability or pregnancy, what is considered a reasonable accommodation cannot be determined by the employer alone, but is determined by several factors, including input from the employee's treating professionals. The Commission may dismiss a human rights complaint if its investigation finds that an employee failed to accept a reasonable accommodation. Discrimination in employment. Case law scenario number 3. Physical disability discrimination. East versus Fundy Roofing and Duguay, 2023. Joseph East worked as a seasonal roofer with Fundy Roofing from April to December every year. During his employment, he suffered a workplace accident that resulted in a spine injury and caused chronic pain. East went on leave to undergo rehabilitation and received workers' compensation benefits from WorkSafe NB. When East was rehired the following spring, he was put on a gradual return to work plan with modified duties. However, Fundy Roofing's owner, Mark Duguay, refused to participate in the accommodation discussions. East also alleged that Duguay bullied, harassed, and humiliated him because of his disability. After East suffered a second workplace injury, the employer claimed that no further work was available and chose not to rehire him for the next season. The Labor and Employment Board found that the employer had discriminated against East. The employer knew that East had physical health issues and tried to make it intolerable for him to continue working at his job. The board further determined that the respondents terminated East because of his disability and not due to a lack of work. As a result, the board ordered Fundy Roofing to pay $10,000 in general damages and to undergo human rights training. The board did not award special damages for loss of earnings, as East found employment with another company upon dismissal. The New Brunswick Human Rights Commission. The New Brunswick Human Rights Commission is a government agency that ensures that the human rights of all the people in New Brunswick are protected under the Act. If a person believes that they have experienced discrimination at work based on one or more prohibited grounds, they can file a complaint with the Commission. Under the Act, the Commission is able to receive, investigate, and mediate formal complaints of discrimination. If investigation of a complaint establishes an arguable case of discrimination and mediation efforts are unsuccessful, the Commission may refer the complaint to a Labor and Employment Board for a formal hearing. During the compliance process, the Commission remains neutral. This means that the Commission doesn't take sides or favor either the complainant, i.e. the person making the complaint, or the respondent, i.e. the person or organization against whom the complaint has been filed. By remaining neutral and impartial, the Commission ensures that the process is fair, unbiased, and objective. This allows the Commission to examine all the available information carefully and find a fair and unbiased resolution to a complaint. For more information on the Commission's compliance process, visit the Commission's Filing a Complaint webpage. For more educational resources on human rights in New Brunswick, visit the Commission's website at www.gnb.ca/HRC-CDP. Explore our FAQs, plain language flyers, guidelines, e-learning, and more resources to continue learning about various human rights topics. We also encourage you to explore the Commission's Human Rights and Employment discussion guide to engage in meaningful conversations about human rights in your workplace. If you have questions about human rights and employment, or would like to discuss a human rights situation with a Commission staff member, you can contact the Commission at hrc.cdp@gnb.ca or 506-453-2301. Thank you for taking the time to learn more about the rights and responsibilities of employees and employers in New Brunswick. Together, we can make our workplaces more welcoming, inclusive, and equal for all employees across the province.